I'm Manoj Singh. I'll be the host and moderator for this discussion, important discussion on U.S. immigration policy. And I want to welcome our panel and guests for today. Thank you, Immigration Attorney Aparna Dave, Immigration Attorney Farhat Ahmed, and Immigration Attorney Ramesh Khurana for taking the time from your busy schedule for this important discussion. I'm going to quickly introduce all the three panelists. First, Aparna Dave. Aparna completed her law school from Boston University. She was an editorial board and staff for Boston University School of Law and has a private practice in Maryland. Welcome, Attorney Farhat Ahmed. Farhat graduated from Delhi University and also Michigan Law School. He practices in Montgomery County, Maryland, and has a more than 30 years of experience in area of employment and family-based immigration law. Welcome. Attorney Ramesh Khurana. Ramesh is an active member of American Immigration Lawyers Association. Mr. Khurana completed his law schools from Harvard University and Punjab University. He also has a law office in Maryland. Welcome all of you. So I'll start the discussion with few questions, and then after a few minutes, when we have covered some of them, maybe these discussions might answer to questions of a lot of people who have joined today. And after that, I'll open it up, and you can post your questions on the FB Facebook chat, and we'll be monitoring that, and we'll proceed from there. So the first question I have for the panel is on the F1 student visa, because lately this was in the news. And President announced that recently that the foreign students might be sent back if they do not have in-person classes. But then there were court cases and he retracted on that. And I just wanted to ask the panel, and anyone can take this question, any latest updates on that, or is it the same status quo?
When you say that President Trump issued a proclamation recently, which basically said that those non-immigrant students, because it doesn't affect other students who are lawful permanent residents or US citizens, those who are in F1 and M status, they were to be affected. But subsequently, as you rightly said in your question, there was a case filed in the US District Court, and then this guidance is basically gone. And moreover, let me tell you, on July 24th, which was just 2 days back, and this guidance has been updated, and this updated guidance clearly says that those students who are going to colleges or universities and they are taking online courses, maybe 100%, which is more than the regulatory permission, but this will stay so long as this country is going to be affected due to COVID-19. And at this point, it is going to cover just the fall semester. So for the fall semester, those students who are in F1 or M visa, now they should not worry. They will continue to enjoy the regular status during the period of fall semester. And after that, there is no guidance available. So this guidance has been updated recently, as I said, on July 24th by the federal agency ICE. I think I answered your question.
I wanted to add that if there are students who are coming from foreign countries first time, if they've never held the student status as of March 9th, 2020, these students, if their school has decided, college has decided that it's going to be 100% online, they are not going to be issued student visa. So you might be going to, say, University of Maryland or Hopkins or any universities. If they are 100% online, then these students will not be given visas if they are coming to the United States first time on a student visa. I just wanted to add that.
Okay, that was my follow-up question. So I'm glad you answered it, because I was asking the people who had already maybe received a student visa coming for the fall semester, what happens to them? And I think that answers the question.
Let me add something here. Thank you, Aparna, for adding that about March 9th issue. Now, the guidance further also says that DSOs are now not allowed to issue new I-20s students. And if these students who are sitting in India with I-20s, Of course, the consulates or embassies are right now shut down because of coronavirus, depending upon the condition in each country. But they are also not allowed to issue F1 or M visas.
Okay, thank you. Any requirements have changed? We'll wrap up with just last question. Any requirements changed for F1 visa? I know that we have to have a certain bank balance and all that. New changes?
I don't believe so. No,
there are no
requirements.
changes because the main consideration is whenever students are allowed to come to the United States, they are supposed to demonstrate to the US consulate that they can financially sustain themselves so that they do not become a public charge. Because the public charge issue is applicable not only to immigrants but non-immigrants as well.
The next question, I'll move on to now H-1B visa. So, and this will be maybe Farhat can answer. President Trump issued executive order suspending H-1B, H-2B, L-1 and J-1 visas and dependents until December 22, citing unemployment in US. Does it still remain canceled? And please provide update.
Yes, that does still remain suspended until December 31st, 2020. But there are certain exceptions to this. People who already, as of June 24th, had a visa, they were able to come, or they're still able to come to the United States. And there are some other exceptions for essential workers that are essential to the food and supply chain. And then also if it's determined that somebody is in the national interest, it would be, they would be also allowed into the country. So, for example, I have several clients who already had visas before June 24th. They have all come back into the country. And this does not just apply to the H-1s or J-1s. This also applies to their dependents.
But there was a court case even for this. Any update on that? I know IT companies are quite concerned.
They are concerned, but so far, there's no outcome from the court cases so far.
I would like to supplement what Farhat said. Now, in a tweet on July 20th, State Department has issued an interpretation because earlier, this was the interpretation that H-1B people who are sitting over here, if they were to go outside the United States to get a visa stamp, they will be denied. Now they have said, if they were here in this country as of June 24th, and if they decide to go back, so they will be allowed to have the H-1B stamp in their passports.
Follow-up question for Aparna. How long nowadays it is taking for a qualified applications with labor certificate EB2, EB3 to get green card, to get to the green card stage? What are the requirements nowadays? And he mentioned about application with US, and I think President Trump mentioned that now preference will be given to H-1B qualified candidates who have US education. Can you shed some light on that?
Sure. I think our administration has been talking quite a bit about, getting people immigrant visas based on merit. I don't think so that any of that has come through. I believe Farhat and Ramesh ji will concur on this. Currently with EB2 and EB3, our priority dates for India, if we are talking just about India right now, is still stuck in 2009. So, we are still 10 years behind. So these are people whose labors have been approved, their I-140s have been approved, but they are just now sitting to, do the final aspect where they need to adjust their status from H or, any other work visa to that of a permanent resident. But that is taking time. So that right now, those priority dates are stuck into 2009. So which means we are 11 years behind and these people are just still sitting to apply for adjustment. Now, how this, the administration keeps saying all the time that, we believe in merit-based immigration, but I am seeing that along with the illegal immigration that is being stopped, unfortunately, asylum is also being stopped, which also I disagree with on humanitarian grounds. But I think the same, we are facing the same thing with immigration, which is related to, skilled professionals. H1s, L1s, J1s, these are all skilled professionals. And I don't think things are getting any easier for them. In fact, I think it's becoming more and more difficult with long waits and long time periods everywhere in the US if they have to go to the consulate. And in addition, there is also this public charge rule that has come into play, which is fine with people who are employed because they can meet the public charge rule. But family-based would be a separate discussion. That could be very burdensome for a lot of people. So to answer your question in short, has anything changed? I think things have become worse.
And I would like to add something more to that. The president can't change anything. It's ultimately Congress who has to pass the laws. So even if at some point the United States adopts a point system similar to Canada, they cannot do it until Congress changes the laws. The current laws remain in effect. A lot of the stuff that Trump is doing is through executive orders, but they're not actually law.
So I would also like to supplement whatever my two other distinguished colleagues have stated. Now, when we are talking about how many years does it take to get a green card, and we are talking about Indian nationals. Now, it has happened. It happened sometimes in the past also, but at this point, as per the August visa bulletin, now EB3 category is more favorable than the EB2. It's July 2009, and EB3 category is October 2009. And moreover, when we are saying that with the priority dates within these 2 days, people can file their adjustment of status applications, that doesn't mean that they are going to be granted green card so soon. I know that people who file their adjustment of status applications several years back, 4 or 5 years back, still they are thriving on EAD cards, and still their green cards are not issued. Thank you.
Okay. So I have another question in the same category. Can spouse of H-1B visa holder IH-4 dependents category continue to work in US? Any updates on that?
Yes.
I will take it. Yes. This is called H4 based EAD. They still continue to have the benefit, and the people have still an opportunity to file their applications to apply for H4 based EAD. And the extent of this H4 EAD is limited to the extent of validity of H1B of their spouse. Of course, Trump administration has been making efforts to stop it, but so far they are not succeeded. And still it's going on because they have to follow certain procedures, and those procedures are still in the offing. Thank you.
And just to add there, Manoj, yes, it's very convenient to say that H4 EAD is existing, but to be honest, what is happening right now is it's taking so long for H4 to get adjudicated because there's no biometric happening. There have been a lot of delays, and I have been getting a lot of cases where spouses are actually working and they cannot extend their H4 EADs because the H4 itself is pending for a very long time. So a lot of people are filing H1Bs under premium. The H1Bs are getting approved, but the H4 or the EADs of the spouses are actually not getting approved for 8 months, 9 months, and a lot of them actually have lost their jobs. So yes, H4 EAD is there, but how useful it is going to be now is a question we all need to ask. And Farhat, if you need to add anything.
Yeah, to supplement that, one of the problems is that last year they started biometrics notices for, biometrics, fingerprints for H4 EADs. So the problem with that is in the last 4 months, they have not been able to schedule those biometrics notices. So if they cannot go for their biometrics appointment, they can't even, basically adjudicate these cases before they get the biometrics. So there is going to be a lot of delay in this. And what some of my clients, even last year, even before this pandemic happened, there was a delay. They would actually go to court, litigate it, and then get their EADs. But I don't know how that's going to work if there's no biometrics, right?
I would like to give my opinion here because recently this week, I had received certain biometric notices for I-539 and H4 EAD. I got at least 10 or 15 of them. So it has been happening. But the major problem is even if the EAD card is approved, whether it takes 5 months or 7 months. Earlier, as Aparna stated, it used to be approved along with the H-1B petition if it was filed under premium processing, not anymore because of the biometric system, which has recently been introduced by Trump administration. Now the problem is, even if it is approved, you get the approval notice, but cards are not being printed.
Correct, yeah.
Because their contract expired and this contract has not been renewed. Now they are trying to give this work in-house to its own employees. And by the way, just 2 days back, our honorable member Robert Cohn, he has filed a case in the US District Court about issuing EAD cards because people are not able to work. And even people who are working on H4 EAD status, if their card is expired, they do not have the benefit of working beyond the expiry of their EAD cards, whereas people who have filed under adjustment of status, they have the benefit of their card extended by 180 days. So they are disadvantaged to some extent.
Thank you. I have a question following up on this. I know because of COVID, we all talked about it, that some of the embassies and consulates have limited hours. Can an H and there is always a concern. I know of several H1s who are in a process, have a labor certificate going through to get a green card status, are scared of leaving US, especially since Trump has come in and so many changes in the policy that they might not be allowed in. So can H1B visa or with labor certificate applicants travel outside of the US and come back?
Absolutely. There is no issue. But in the current environment, they have, unless they have a valid visa, they shouldn't even go out of the country. Because
so
if
I know
they don't,
some have not gone home from 7-8 years, scared that.
That is just paranoia. Because I have clients who come and go all the time. But recently, there have been several of my clients who went in February, March to attend weddings of relatives or parents were sick, but their H-1B visa had expired. So there's a difference between H-1B status and H-1B visa. So their H-1B status was extended here, but if they go out of the country, they still have to get their visa stamped to get into to come back into the country. But several of these people are stuck in India because first the consulates were not open, and now this proclamation. So even if they get the visa now, say in October or September, October, they're still not going to be able to come to the country till January 1st. Mm-hmm. So that is unfortunate. People who are already working for companies, they were, are not able to come back because of this proclamation that was issued on June 24th.
So what Farhat has said is basically people who are stuck in India, their H-1B petition had expired or visa expired, all of that can file a new extension petition because USCIS is accepting. There's no problem. But only problem is because that person was not present in the United States on June 24th when the President's Proclamation 10/0052 became effective. Then that person cannot apply for the visa stamping in his passport at the US consulate if US consulate is agreeing to take up that case because he was not present in the United States on the effective date of the proclamation. That person is stuck at least up to December this year, and it might be extended. This is what the proclamation says.
Okay.
Only if Trump comes back.
Only that's true.
Okay,
And I just wanted to add one more thing is that even people who've gone back in December or January, some of my clients, it's very convenient for the consulate to put these cases under security check. And if a case is put under security check, the consulate refuses to give any updates. So there are a lot of people actually who've applied for visas in February. They've put their cases in security check. And unfortunately, the cases are now all up in the air. So a lot of people who actually have gone back in December and January are also stuck, which are, pre-COVID and had nothing to do with COVID. So to make long story short, stamping is now also becoming a problem, even when the proclamation was not announced, actually.
But these kinds of people are out of luck anyways because they were not present in the United States on the date of effective date of proclamation. they won't be issued visas even if the cases were stuck in the security checks.
Okay, now I'll move on to another category, green card. Many U.S. green card holders are stuck in the respective countries in India because they went and then of course there was shutdown and they can't come back, or they went earlier. But normally there is a myth out there that you should come back to U.S. every 6 months or 1 year to get a stamp, even if you have some emergencies in India, because one, you might not be allowed in, or they might take away your green card, and second is that you might even have issues when you apply for naturalization, becoming a US citizen. So I know that uh, what do these people do if suppose they were expiring in June, July, and there are no flights? I know you talked about the SB1 application. Yeah. So can you please shed some light on that?
Yeah, I can do that. Now, basically, what we are stating here is that if a green card holder is staying at one particular time outside the United States, so more than 6 months, usually there is not a problem if the track record has been good. Like it has happened only once, because we are discussing this situation in view of the pandemic. And we basically started from February, March, when the flight stopped. But yes, regulation states if a person who's a lawful permanent resident or a green card holder, if he stays outside the United States for 1 year or above, then of course he is considered to have abandoned his green card. So this is called the abandonment. But this can be discussed in two ways. First of all, if he comes here in the United States, takes the flight, airlines are not going to stop that person in taking the flight. They are looking at the green card only. They do not care whether the person has abandoned his green card as per the laws of the immigration. But the problem is when that person reports at the CBP, Customs and Border Protection Force, now they are going to ask him questions. So it is being anticipated at this point that because of COVID-19, that person will be allowed to come in, because there cannot be any better reason than this COVID-19, because it was simply beyond the control of that person. And this is what we have to prove, that if this is something which is beyond the control of the person, a person has been keeping good ties with the United States, like he is basically a domicile of the United States, filing a tax return, doing some job or working here, and having a lease of the house, keeping bank accounts. So of course he should come fully prepared. Then this person is not going to have any problem. But if he thinks that he doesn't want to take any risk to come at the CBP door and knock it, oh, I want to come in, and CBP says, sorry, you cannot come in. Then of course, as we were saying about SB1 application, then better he goes to the consulate, makes an appointment, and there he explains, basically, this is the reason that I have not been able to go. I don't think that why that SB1 application will be denied by the consulate. I think that way answer is more or less complete to your question.
No, there's just one caveat, Rameshji, that I was just reading is that if you are doing an SB1, you do need to resubmit the affidavit of support. And when you're, so my concern now is to having these people go and get SB1 is that if affidavit of support comes into play, then again, the public charge situation comes into play. So that is always a fear that if the public charge system comes into play, and if there are parents who are traveling, there are a lot of older people who are actually stuck in India. I know some of my friends' parents are stuck, and that is the issue now, that how do we deal with this? So I don't know, I would just pose this question to Farhat and Rameshji. Do you think it would be a good idea to send an email to the consulate asking them this question, that this is the situation, people are staying longer. Is there anything that the Department of State has come up with? I mean, what do you both think?
Yeah, sure, I can answer this question. When we are talking about SB1, SB1's part is simply confined to the fact that you are making an appointment, you go and meet with the consular officer. This is in the first stage, because I have practically handled SB application. So the applicant goes there, the applicant is interviewed by the consulate officer, he approves or denies. So if it is approved, Then he has to go to the second stage where he has to follow all the requirements which a person who's coming as an immigrant, he has to follow, like filing DS-260, paying all the fees which are to be payable for affidavit of support, of course, $120 and 355 other fees, visa fees. And after that, he has to go for the medical examination. He has to obtain the police clearance report. And then, of course, you have raised a very important issue, Aparna, about the public charge issue. Yes, then, but good news is about the public charge issue. Now, it is being strictly enforced while a person is here in the United States and filing an adjustment of status application. But as regards consulates are concerned, you might have seen when you are filing your papers with the NVC, they are not filing for Form 5540 or public charge issue. Not yet. In fact, it has happened. I called once NVC to ask a question. It is not showing up here. Should I file my 5540? And the supervisor of NVC said, what is 550? So this is not being enforced with the consulates, and it depends upon the policies of the local consulate, how much they are going to see at this point. What happens tomorrow? We do not have any idea.
I want to add something to that. Actually, that form is supposed to be given by the immigration applicant at the time of the interview. You have to present that form, but not to the NVC, but to the consulate at the time of the interview.
But
that is where it comes into play.
What I am doing, Farhat, is I am even filing 5540, although they are not created under any category. Under other category, I have filed DS 5540. It is just a 4-page form. Unlike I-944, which is an 18-page form. And here we are basically asking that you prove that you have got the health insurance. And especially when we are talking in respect of the SB1 applicant, the person was living here in the United States, probably he must be having the health insurance policy, which is not an issue. Otherwise, the person has to undertake and file an undertaking with the US consulate that as soon as I arrive in the United States, within 30 days, I will obtain my health insurance policy. So, which should not be an issue. And probably he was working or he was dependent. So, I don't think that's going to be a cumbersome issue.
In the same category, I had a question about, moving on from green card. How long is it taking for the green card holders to get naturalization or US citizenship? And I know it's becoming harder. I heard, someone talk about already that they're even revoking naturalization. They're getting, if in the scrutiny they find out that the information provided was not correct. And I've also heard about denials and several cases like that. Can you please shed light on that?
So naturalizations are taking about 8 to 10 months. I don't know what the experience of Aparna and Ramesh.
Depending upon the jurisdiction.
Yes, but it is, they have, the Trump administration has talking about, going back. The Trump administration has established a division which is going after people who are already naturalized. There have been several, like 600-700 cases who've been revoked, where naturalizations have been revoked. And I know of a case recently where a woman actually went for her naturalization. She had an employment-based case. It's not my client, but a colleague had a case where they, at the naturalization stage, decided to go into her look into her I-140 approval notice and decided that she was not qualified for that position, EB3 position, and then put her in removal proceedings. Can you imagine?
That's scary.
I also, in fact, handled a case, co-counseled with another lawyer who is an ex-department lawyer of Department of Justice. And this person's case basically was scrutinized, and denaturalization proceedings were started in the court, US District Court. But prior to that, Department of Justice sent out a letter to this person They said, this is what has happened, this is what we have found out from your case file. And you had basically committed a fraud or misrepresentation while providing information to the USCIS, and he had been using 2 or 3 names, and he came here and he was removed from the United States. He re-entered on a different name. All that kind of dirty stuff was there. And they wanted to make a deal with him that they said the minimum term of the settlement is that you accept denaturalization. So there was no conversation of retaining by him the lawful permanent status. So we negotiated with them, and we found out the case was very weak, and we gave him all the options, and finally he decided to listen to our advice. He accepted for denaturalization and retained his lawful permanent residence status. Only thing is, when we signed the agreement with the Department of Justice, they said that they do not have any plans to remove him or take away his lawful permanent residence status, although we cannot guarantee it. So, Manoj, yes, denaturalizations are taking place because there are expanded vetting procedures in place. They are spending a lot of money. That's why they have become bankrupt, and they are asking help of 1.2 billion because they have been wasting their time on unproductive matters. So they should be focusing on customer services for which the USCIS is made. Yes, thank you.
Thank you. Following up, another question. What is the sponsorship time period of family members nowadays? I remember when I came in the 80s and they were, pretty decent for wife, mother, father, brother, sister. But now I've heard there are years. Could you provide some information about that?
Yeah, sure. So immediate relatives of US citizen, I think that is still, there is no wait period, which includes parents of United States citizen, spouse, or children under the age of 21. So those categories are still okay, but I think there is a long wait with sibling category, which I have a feeling that at the end of the day, I don't know what it's, I think right now the priority date for a sibling category is 2005. So we are talking about more than 15 years wait. And similarly, the waiting period for children of United States citizen over the age of 21, married children, is not that bad. It's about 3 or 4 years. And unmarried children of United States citizen is also not that bad. So I think if you're talking about the US citizen category, except for the sibling category, other cases are, the wait period is not too long, but it is, we really need to see that how long this is going to be extended. Right now they are saying 4 years, but are these dates even moving actually? The only good thing is that if currently the F2A category, which is spouse, children under the age of 21 years old of green card holders, those dates are actually current right now, which is great news. If people are here on a different status, married a green card holder, yes, their dates are current and they can apply for I-130 and I-485, just like an immediate relative of a US citizen can do. So those are some of the good things. And I think I will let maybe Farhat talk more about the public interest problem that might come up in these family categories. And Ramesh ji can add to that, because again, that is a caveat that we are dealing with in family-based cases and could be a more serious challenge here. So if you guys want to continue on that part.
I think the challenging part is going to be more for like middle income or lower income families, not for higher income sponsors. So, because under this new public charge rule, you have to establish that in determining whether these people are inadmissible on the grounds of public charge, education, financial assets, age, whether, what skills they have. So I would say that it's going to hit more lower income and middle income, not the upper middle class. So if Ramesh wants...
This age factor is very crucial now. Now, basically, any applicant who is already here or filing an adjustment of status or coming from India, for example, through the consular processing, Now that person has a lot of negative factor attached to it because of the age. And depending upon the health condition, which Farhat also mentioned that, so then that person has to show if that person is coming to the United States, whether self-sufficiency test is met fully or not. And if self-sufficiency test is not met fully, as per the estimation of the consulate officer, I think he is going to deny that application because of the public charge rule. And he will say the person is inadmissible. This will happen.
You're talking about
This rule came into being as from February 24th, 2020. And after that, all consulates got closed. So we do not have real life experience. Although we have filed so many applications here for the adjustment of status candidate and for the US consulates, but so long as we don't have the real experience, like how US consulates will be handling those applications.
So basically what I hear is clearly that, initially to have parents come into the United States was fairly easy. Now, if the parents are older, not working, retired, I think it is going to be a challenge to bring them in based upon the public charge rule, even if they are immediate citizens, immediate relatives of US citizens. Am I correct?
Yes, you are correct.
Yes.
For the time being, the bigger problem is that even parents of US citizen children, they cannot be even interviewed because of proclamation 10.052 up to December 2020. They are basically excluded. Only people who are allowed to come in up to December 2020, these are the children who are under the age of 21, spouses of US citizens.
Another thing I think President Trump announced was a suspension of issuance of green cards via US embassies or consulate in foreign countries until December 2020. Does this also hold?
Yes.
Yes.
And any changes in the process of getting a citizenship, like more stringent requirements, or I know when we had discussed about out-of-country travel for green card, that might come into account. Are the forms same, or they've gone longer and they want more information? I hear also about more denials and restrictions.
There are expanded vetting procedures in place. They are spending a lot of time in basically testing every answer of the application by checking the records. So to give you one example, a person who comes into the lawful permanent resident status through EB2 or EB3 category, let us say his last employer was A, and his green card was approved based on the A employer's I-140 petition, and this person, on getting his green card, decides to leave that employer. If that person's job is terminated, then it's a different matter because it's out of his control. But if a person resigns on the second day, I have several cases like that. People don't really work for the employer who basically is supporting that person by way of filing I-140 because maybe there was something else going on. So those kinds of cases, because you give your employment history for the last 5 years, and they look at it, and they find out that you didn't work immediately after you were granted your green card, and they are going to look into that aspect, and they are going to deny that you basically committed a fraud. You said that you will be working with the employer after you are granted a green card, but you actually never worked. I always tell my clients, please make sure, if at all, you have to move away from the current employment, you should work at least for a period of 6 months. Don't leave that employer, so that otherwise you are facing the challenge at the time of your naturalization application. So this point has to be kept in mind.
The physical residence, Manoj, the physical residence requirements have not changed. You still have to have been here at least for, 2.5 years in the last 5 years, but they don't have to be consecutive. But that is why one of the reasons when my clients ask my advice as to how often or how long they should stay, people, people who aspire to become citizens of this country should stay at least for 6+ months every year to be eligible.
Is it also good to file all the papers like tax returns and everything every year?
Yeah.
Absolutely, because that goes to good moral character.
Yes, correct. Yeah. Okay.
Moreover, in the tax returns, one question is asked, basically whether you are a resident of the United States or non-resident. And there is one question in the N400 application also, whether you ever file your tax returns as non-resident. Because the way this resident or non-resident tax status is decided, whether you have spent more than 182 days in India or here in the United States. So you save some money by way of paying your taxes, but you are in trouble, because you filed your tax return as a non-resident. So we have to be careful, and they are looking at these kinds of cases. And in terms of adjudication standard, my experience is if any person whose physical stay outside the United States was between, let's say, 184 days to 365 days, because there is only a presumption that you have abandoned your residence, unless you prove it otherwise. I was very easily able to overcome that presumption by showing that this was something, maybe medical reason, or the person was going to a college or university, he was doing MBBS or engineering from India. I would say he was a student, he wanted to complete a degree. That was the reason that he couldn't come back in 7 months. And they will grant that kind of waiver, but not anymore. This is where I find they have become very stringent.
And I would also like to add that in the current global situation, there are a lot of green card holders or a lot of clients who I work with where they have offices in the United States. These are green permanent residents, but then they are required to go and live in other countries to set up an office. It could be India, Europe, wherever. And I would recommend those people that before they try to leave the country for, there is a way in which you can preserve your residency if you are working for a US employer. So it is always, it's a case-by-case scenario. So it's always a good idea to seek advice of an immigration attorney, whereby, you need to understand that if you are going to be working outside of the United States as a permanent resident for the same employer, how you can preserve your residency. So please keep that in mind. And I think that's important for people, to do that before they decide to leave the country to work for their employers.
That's a good point.
Good to know. Good to know. There's a question from the audience to Aparna about visitor visa. Any changes in visitor visa application process or requirements?
As far as I know, there are no such changes, but as people who have a visitor visa can always come into the United States. The question might be if people who do not have visitor's visa, and how would they apply? I think the consulates are very clearly saying that they will be stamping visas for essential travel. I have actually known a case where a child in the US was very sick on a student status, and the parents had to travel from India, and they wrote an email to the US consulate, showed them all the documentation, and they were actually given an appointment within like 3 days to go and get stamping done. So emergency visas are being given. So if people do have such emergencies, I encourage them to apply, email the consulate and get an appointment, and they are considerate about that. But for non-essential travel, as far as I understand, the consulates are not giving visas at this point, B1, B2. But if people do have B1, B2 visas stamped on their passports, yes, they can definitely travel. If Farhat and Ramesh, you want to add anything more to that?
Yes, I would like to just add one thing, that whenever you want to seek an appointment in an emergency situation, because for the purpose of appointment, you have to file the form DS-160. So while filing form DS-160, now there is an option. You can say that I am requesting an emergency appointment. That's the only place where you can request emergency appointment, which is part of this DS-160 process. So I will suggest to the audience to take benefit of that section at this point.
Thank you. Another question, and Ramesh ji, for you, because I think you do practice DACA. What does DACA mean, first of all? I know a lot of people don't know that. And in June, Supreme Court decided to uphold DACA. Please provide more, what information you can give us.
Sure. Manoj, DACA basically stands for Deferred Action for arrivals of children or childhood arrivals. So this program was started by President Obama by an executive order. And there has been a lot of controversy after the Trump administration took power. And Trump administration basically wanted to discontinue this DACA program in 2017. And there has been a lot of litigation. And finally, the case went to the Supreme Court. And Supreme Court has recently ruled this DACA case. And that has gone against the decision of Trump administration, fortunately. Although it was a very thin win decision by 5-4, and Supreme Court Chief Justice, he was on side of DACA program. So just to tell you that requirements of DACA program continue to remain the same as these were envisaged at the time of introduction of this program by President Obama. So a person who is considered for the DACA program, he must have entered the United States when he was under the age of 16. And there are certain dates which are very crucial, like June 15, 2007, this person must have stayed here. And secondly, that this person should have entered without inspection or unlawfully. Or if a person entered with inspection, then this person must have become unlawful before 2009. So, in fact, I recently filed one application after the ruling of Supreme Court. And this person had entered the United States in 2007 in H4 status, based on H1B status of his father. After 3 years, somehow the lawyer forgot to file H4 application, extension application for the son and the wife. And now their status became unlawful. So this boy has been going to the school and now he's in the 12th grade. When I looked at his case, so I discussed with his father, I said, it's a good case to file now because there is a strong rumor that president might stop it by permission. I said, now here is a small window because right now there is a Supreme Court ruling. If you want to file it, of course, the downside is that you will be wasting money because you have to pay a $495 fee to the Department of Homeland Security and legal fees are also there. I said, if you want to take a chance, this is the window. And he decided to go for it. And I filed this kind of applications 2 weeks back. And so far, the packages have not been returned, but certain colleagues who are part of our American Immigration Lawyers Association, they have shared their experience that only one person has got the rejection notice of the package. I think they are thinking about them, but at least there is a thought going on filing some kind of lawsuit against the Trump administration. But so far, USCIS has not issued instructions that we are accepting DACA applications. But those people who are waiting, I think just look at the downside. If you don't mind wasting some money, file it so that you are standing in the queue. Otherwise, who knows what will happen.
Okay. Thank you. Moving on to another category. This is a question from the audience, from the attendees, is EB5. Any changes in investment visa given the COVID-19 and economic environment? Is it still the process same and it's being issued?
You want me to take it? Okay. As from November of 2019, the investment amounts were raised. And if it is a targeted unemployment area, the minimum amount of investment is 900,000. It used to be 500,000. It went up by 400,000. Otherwise, in other cities and towns, now it has been raised to 1.8 million. And other criteria regarding creating jobs for US workers, that requirement remains the same. Now, there is a provision when we are talking about the enhancements in the amount of investment. Now, these have been linked to the inflation. And there is an automatic provision after 5 years. If the consumer price index is going up, this amount will also go up. Now, another major change which I am seeing here is about 6 or 8 months back, the priority date was about 54 months back. Now, EB5 priority date for Indian pass holders, if we're talking about Indians, only it's not current is for Chinese national, but otherwise it has become current. So this is a good opportunity, but there are some challenges. Whenever a person wants to come from India, you have to show your legitimate funds, which can be proven. And even if somebody is giving you a gift, so Department of Immigration is going to ask for that person's 5 to 7 years of tax returns to show that there is no money laundering involved and these are legitimate funds. So that's why number of applications has gone down from Indian nationals after these limits were enhanced in November of 2019.
And I also think there's a recent policy memo that was issued on EB5 that there has, the USCIS is going to change some policy on the way these investments are made. And I think there's a comment period open till August. So we will have to see what they are trying to come back with, stating what kind of investments will be allowed, not allowed, how the money should be invested. So I think that policy memo is being discussed. Maybe we'll have more changes possibly by the end of the year.
So it's interesting because, given the economic situation, I would think that US will want people to come and invest in US because they want to create jobs in US and and want to help the economy. But it seems like Ramesh ji mentioned, that's becoming more stringent. And I can understand that, in India also, they've deferred the tax dates from normally it's in July that you file your tax return, but now it's November. And another thing India is starting, I don't know whether you guys know, and must be knowing, that right now we have to declare in FBAR everything we own or have in India, like the tax, all the bank accounts and everything. But India is doing the similar thing. They were going to start it this year, but they might be deferred because of COVID, that we have to declare everything now in India, that what we own in US and the investments and everything. It will work both ways. So it makes sense that EB5 will become quite a stringent process. People have to prove where that money came from because of what this money laundering and terrorism and all of that. Any other point you want to make, Farhat?
In fact, EB5 visa immigrant, they're exempt under this proclamation. People who want to come, they do want the money, but they're stringent, but they want people to come. That category is exempt from this proclamation of April 23rd, that EB5. So US is encouraging people to invest. They are becoming more stringent, but I'm sure in the future, with the economic downfall in this country, they would like to attract foreign investment. Maybe they will be more relaxed, depending what Aparna says, they're revisiting this issue. So maybe they will be more relaxed about this. They will not be as stringent. We'll see.
Well, yeah, hopefully, after November, if anything changes, then of course all these things will be reconsidered. So another audience question, that as an applicant, regardless of visa types, what do they can do? Because seems like more and more information and documentation is required, and people are being scrutinized and denied. How can they make sure that the application is really good? Of course, they need to consult an immigration attorney and work with you. But what advice will you give them that keep these kinds of papers, keep a record for 7 years, 5 years, your tax return, all of that? So can you please shed some light on that?
So I think your question is a little bit broad because it doesn't talk about the specific type of visa petition. But generally speaking, I would like to advise the audience that be truthful. There is all the more need to be truthful. Like I already alluded to the fact that there are vastly expanded vetting procedures in place. USCIS is willing to spend more and more time to find out if somebody is trying to misrepresent here. Even if some person who just made a kind of wrong answer 5 years back while applying for B1, B2. Like they asked him a question, do you have any relative in the United States? They answered no, because this is how people who are sitting in India working as agents, they advise them, oh, don't say so, otherwise you'll be denied. So I came across a situation where a person moved from India to Canada, Canada to here, while the adjustment of status, they went back and found out that 7 years back he had denied having any relative. But the affidavit of support we provided, that was from his uncle. So they said, oh, by the way, this is what you had said 7 years back. And now you're providing an affidavit from your uncle. Anyway, we had to file a waiver because he had married a US citizen wife. So waiver was granted. And that was a good time about 2 years back. I don't know if we will be successful in having a successful waiver application even now. So in this, I would like to say, be truthful. Just tell the truth, which can be easily documented. You will not be having any problems. Thank you.
Good advice. I mean, I always hear, even when I came, that embassies in respective countries also have their ways of finding out the truth in the country you live in. So people have this thing that how will they find out that I said this or that in India, or what I have and I have not. But that's a myth. Could you talk about that, please?
Yes. Most of the US embassies or consulates, they have fraud detection department. And certain cases which appear to be suspicious, so those kinds of cases are vetted by the fraud and detection department, and they will really go and visit the villages of the people where they have been residing and go to the cities and towns. They are doing it. One senior officer from the embassy along with local support staff, they visit those people. They will ask that question from the neighbors. They will ask that question from the relatives. And moreover, the way they find out, when the person for whom this immigration benefit application has been filed and the person is being interviewed, they will say, okay, give us your phone. And in the phone, they will see like which are the people she had been talking to in the last 5 to 10 days. And if that lady is basically arguing that I'm still a fiance, whereas she already got married, so they will ask call those 5 numbers, and they will ask them, do you know this person? And do you know whether she is married or still single? And answer is available. So in making 5 or 7 calls, they will find out. I know one case where this lady was interviewed 5 times on the same day. 5 times on the same day. So this is their vetting procedure, not that, FBI is sitting there. FBI must look into their databases and find out if that person's record is there. They of course do eliminate it, but this is the way they find out.
I just wanted to add that I have seen a couple of cases in the past few years is, marriage-based cases where a lot of times, US citizens are going from here, getting married to somebody in India, but they want to hold the Hindu ceremony at a later date, or, their religious ceremony at a later date because they want more guests to come. So these people go, they like a girl, they get they do a registered marriage, and then they come back and they file the I-130. And I've had 2 cases in which the consulate basically has said that, yes, you are married, but the marriage is not commemorated because they know in India, a religious ceremony is very important for a boy and a girl to stay together. And there was no fire done, because it was a Hindu ceremony, there was not a fire. Or if it is a Muslim ceremony, they did not, follow the guidelines of the religion. And they basically denied those cases. And they said, denied in a sense, you need to come back, do the proper religious marriage, and then you go back. So I don't know, they may have talked to the fraud detection department. Possibly the registered marriage was never declared. It was done secretly. We don't know what happened. But the council officers are actually looking at not only the registration now, but also the religious wedding part that has to be completed before you file an I-130. Some cases may have gone through, but they are creating this problem. So I very strictly tell people, if you're going to go to India, just get married. You can have a fancy wedding or whatever, post whatever you can do later, but just do a proper wedding and don't cut it short and create problems for yourself. So I've seen that happen in the
Thanks,
past few years.
advice.
To
I
add
agree
to
with you,
that,
Aparna. I have a similar case where marriage took place, and the lady is from Maryland and the man is from New Delhi. They got married. They got the marriage certificate issued by the registrar of marriages, and there were a few pictures, but there were no pictures of the Fera ceremony. And that boy was interviewed at the US consulate in Mumbai, and that officer said, "Show me the Fera pictures." First of all, she asked him, "Did you get Feras?" Yes. The fact was they never had Feras because the wife said, "I don't believe in fire. I don't want to go around the fire." This was wife's opinion, and they didn't have Feras. And the officer was not willing to accept this fact that there are no Fera pictures. But again, finally, after exchanging a few emails, I was able to convince the officer that this is a fact, that because this lady didn't like it, and this is the reason that they decided to just go for that marriage. So they accepted at the end, but this became a big issue. Family was worried until that visa was granted. I think it's a good piece of advice, Aparna. You need to document. And that day onward, I always ask people, where are Fera pictures? Give me at least 10 Fera pictures. And I always enclose those 10 Fera pictures with the I-130 application. I made it a point. This is how we learn from our experience.
Farhat, you were saying something also?
yeah, I wanted to supplement that. Also, they can get a lot of information from social media. The PS260 form now, we have to actually give IDs. People have to give their passwords for the social media.
Yeah,
So
that's even
yeah, so a lot of the information, suppose people come here and decide they have the religious ceremony, but they haven't had the register, they haven't gotten the marriage registered, but they have pictures all over Facebook of their wedding, and then they go for fiancé visa.
yeah,
So-
all that has, in fact,
That's a
even the
very funny
US.
situation.
And
Even
this is recently they have been asked. There is a question on these forms, the immigrant visa forms, that give us your IDs, your passwords and stuff, and you have to.
That's become,
Oh,
in fact,
exactly.
even a requirement for the US employers. They've started
Yeah.
looking at Instagram,
Oh, yes.
Facebook, Twitter, LinkedIn. They
Yes.
cross-check to see whether you're saying the right thing.
Absolutely. And that's why when I'm preparing, if I prepare an H1 if I look at the employer's profile to see what's on the website.
That's true. To just make sure that they are using the right information.
It's consistent.
Yeah.
Right. So because
So I think it's about time we'll start wrapping it up. So I wanted to ask, first of all, thank you, all three of you, Ramesh ji, Aparna ji, and Farhat, for taking the time to join this discussion. Where can the attendees go? I know USCIS has a website to find the correct information. And where can they get the latest updates on their visa application status or even green card or naturalization? Could you please maybe give some information about this website?
Yeah, sure. As you rightly said, that USCIS is one of the three federal agencies which are controlling the immigration processes. And the second agency is the ICE, and third is the CBP. And of course, the fourth agency involved is State Department, which controls the US consulates and embassies. So these are very, very useful websites, and you can get to know all the information by visiting these websites. There are certain law firms which have come up very well regarding putting up the information on their law firm website. Say, for example, my law firm has more than 100 videos on its website, and these videos are also available in YouTube on every particular topic. Like you are going for the marriage-based interview, so it will tell you like what are the pitfalls and what you should be prepared for. And I'm sure all my colleagues, they have their websites and they have very useful information. So information is available significantly, and it's a question of spending time and finding out. But I would like to add a key. You know, when people read that information, they read certain blogs, and certain blogs, who are the authors of those blogs? Maybe they went through the process one time, and that person thinks that that he has become an expert. He understands the procedure. Unfortunately, it does not. Like, we have handled hundreds of cases, and still we think that we have to learn every single day, and I'm still a student. So it's always better, Manoj, as you said, it's better to consult an experienced immigration lawyer before you commit to any process. That will be very useful. Thank you.
Any other comments? I mean, I will tell the attendees that this is my recommendation as well. So you heard over an hour that that so much more information is required. There's a lot more scrutiny. Tell the truth and definitely get a professional's help because they'll guide you. So thank you all very much for taking the time to be on this panel, and also to the attendees. And I really appreciate your time. Thank you all, and have a wonderful summer, whatever you can make out of it. We are all in lockdown, but thank you all again.
Thank you very much, Manoj.
Thank
Thank you
you.
very much.
you.
Thank you.
Thank you, Farhat. Thank you, Aparna. It has been a great pleasure working with you on this side. Appreciate it.
Thank you.
Thank you, Farhat and Ramesh ji, and thank you very much, Manoj and
Thank you,
Ethan.
Ramesh and
Thank you.
Aparna. Thank you very much.
Look forward to more opportunities working
Thank you.
this kind
Thank
of
you.
All right.
seminars.
Thank you.
Thank you, Manoj,
Have a
for
great
organizing it.